Norbert Schweizer is going to talk to us this afternoon on wills and estate planning. He does happen to be the Sando family solicitor, but I've worked with Norbert a lot over the years in the corporate world, and he and I have a passion in common, and that was the Swiss Australian Chamber of Commerce and Industry. Norbert's the founding secretary, and I was the president for a couple of years. So without any further ado, I'll ask Norbert to come to the floor and present.
Firstly, thank you very much, David, for the invitation to come up here and talk to this group, and I'm delighted to be able to do so. As David mentioned, our association goes back quite some years to the Swiss Australian Chamber of Commerce, which is one of my passions. The other passion is, strangely, estate planning, which is a little bit hard to understand. But I was delighted to be able to present to you just a high-level overview of some of the key issues that are involved in estate planning, in will making, in putting your wishes together. And the sorts of things that we're going to look at today will be basically what is estate planning, the role of executors and how you go about choosing them and their responsibilities, the role of trustees and the difference between executors and trustees and their duties, what is the effect of making bequests in your will to individuals or to institutions, the flavour of the month, testamentary trusts, particularly testamentary discretionary trusts, and the tax advantages and asset protection advantages that those can give, claims by what they now call eligible persons under the Succession Act, other estate planning tools, things that you can do to assist in managing your affairs, and the final thing that's not up here on the contents page is I'll show you the best will I ever drafted. This is my CYA, cover your ass. So what I'm going to be talking about today is just very general, but as David mentioned, please feel free to interrupt me at any time if you have any questions. What is estate planning? The idea of estate planning is not simply to give everything to whoever you want to give it to, but to do it in a way that is going to be tax effective, particularly for the people who come after you and the people you're seeking to benefit, and to do so in such a manner that is going to give them the most protection and your assets the most protection, so that anything you plan to leave to anybody is going to be preferably not available to any creditors, or what I call creditors or predators. And also to do this in a way that's going to take into account the needs of the beneficiaries, the people perhaps in your family that need some special consideration. If you have any children that may not be entirely able to look after their own affairs, that might have a disability, a mental or physical disability, what structures you can put up for them. So it's not simply just writing a will. I give everything to my wife, and if she fails to survive me, then I give it all to my children. The role of executors. Strangely enough, when you die, the person who's entitled to your body is your executor. It's not your family, it's not your wife, it's not your husband, it's not your children, it's your executor. And if there's ever going to be a dispute about what your funeral arrangements should be, then it's your executor that makes that decision if the family can't come to a proper one. The way our legal system works is that on death, provided that you have a will, the whole of your estate, everything you own, that is everything in your own name, becomes the property of your executor. and it'll be up to your executor then to deal with that property, those assets, in the way that you have specified in your will. So choosing the person who's going to take on that very important and very responsible role is probably one of the most important decisions that you have to make when you're planning your will. And what is it that the executor does? And might I say at this point, you can have one executor, you can have two executors, you can have three, you can appoint an individual, you can appoint a statutory trust company, ANZ nominees or the public trustee, if you wish. You can also build in provisions about how they should be paid, what should happen if you have two or more executors and they don't agree on something. You can build that all into your will. But the role of the executors is to obtain the probate. That's the primary role first up. Probate is effectively a certification from the Supreme Court that the executor can deal with the assets that you own and then deal with them in accordance with the will. It's an onerous position because the executor is personally liable to pay estate debts. So if you have left a situation where you've got an outstanding tax liability, then it's the executor's job to make sure that that gets paid before any of the assets are distributed. The executor, once all the assets have been, as we call it, collected, property put into the executor's name, bank accounts closed, monies collected, then transfers the relevant assets to the beneficiaries that you've named in the will, or gives them to the trustees to be held on the trust that you've set out in the will. Now, I mentioned that the role of the executor was an onerous one, and that's why I think it's important that you should only appoint people that you know and trust, that are going to be competent at carrying out that work, and who agree to do it. There's no point in appointing somebody who's then going to regard it as a burden and not want to be willing to carry out what you want them to do. Trustees, on the other hand, are the people who take on the role in an estate after the executor's role has been completed. You can appoint one and the same person or people as your executors and trustees. They may just have different roles. If you have, rather than given your assets or a particular asset to a specific person, but say given it to children when they reach a certain age or to grandchildren when they reach a certain age or on certain conditions, it's going to be the trustee's job to look after those assets until those beneficiaries have reached whatever is the vesting condition that you've placed, and they have the obligations to make sure that those assets are going to be available for those beneficiaries. They're particularly important in what we call modern wills, because in modern wills you usually set up trusts, testamentary trusts, and I'll come to those. Again, because the role of an executor is an ongoing one and it's a very responsible one and it may be one that continues for quite some years, it's important to choose people that you know and trust. Preferably also have among them some people with financial knowledge, be that your accountant, your financial advisor, somebody who understands a little bit about financial matters and has some financial savvy. Warwick, I know, Warwick and I have been working together also for quite some time, so there's somebody with some financial savvy. Also, consider the question of the remuneration that you, if any, that you're going to give to your executors, particularly if you're going to appoint, say, somebody from your accountants or your lawyers. They will be entitled to charge a fee. Work out with them what is going to be a reasonable fee, whether their normal professional fees are going to be appropriate. Maybe it's an hourly rate, maybe it's a lump sum, maybe if you've got your mate to do this, you don't want him to do it just out of the goodness of his heart. Fix a fee and write it into the will. And again, get their consent before you tell your solicitor how you want to, who you want to appoint. Bequests, very simple. I give X, I give $1,000, $500,000, I give my house at wherever to so-and-so. That's a general gift. Or you can make gifts for specific purposes. I give so much money or such percentage of my estate to the Adventist Hospital for the purposes of prostate cancer research. Then you know it's going to have to be earmarked for that particular purpose that you've set aside. I find it best usually to talk about percentages, a percentage of a net estate rather than a fixed sum of money, because between now and whenever the will comes into force, you don't know really how much money is going to be available. Is that going to be a large proportion or a small proportion of your estate, or what assets are actually going to be in your estate? But if you say, I give 5% of my residuary estate to X for this purpose, then it's always clear that that's the amount will have to be assessed when the time comes. And can I come back to one point when I said when the will becomes effective? A will only becomes effective when you die. You write a will today, you sign it, it's not effective until you die. That's why you can replace the will or alter the will any time, and as many times as you like. If you do it every second day, somebody's going to wonder about your testamentary capacity, but if you want to do it, you can. One of the issues with making bequests, and you're giving serious consideration, do I make a bequest in my will, particularly to a charity or an institution, is do I wait and do it in my estate, or do I do it while I'm alive? The basic consideration is that your estate, if you give money to a tax-deductible recipient, will not get a tax deduction. Whereas you, if you give it while you're alive, will get a tax deduction. So think about if you're going to be benefiting any institutions or any organizations, are they tax-deductible recipients? And if they are, do I want to really do this while I'm alive, or do I want to wait till I pass away? The other thing to be careful about is that you correctly name any institutions that you're going to give them to. There's this wonderful little book available, the Australian Charities book, and that lists just about all the Australian charities in Australia with their correct addresses and ABNs, and that's a very handy tool that if you're not sure about how something is particularly named, to have a look in there. The other important thing is that if you are going to make specific gifts out of your estate, you must give a general gift of the residue of your estate to avoid intestacy. Intestacy is when you die without a will or with only part of your estate covered by your will. The portion of your estate which is not covered by the will is called the intestate portion. So to avoid intestacy, you have to cover it all in your will, because if anything is intestate, then it'll go by a whole series of different rules, and those rules may not be what you want. You may be aware that recently the law was changed so that if you die without a will, everything you own goes automatically to your surviving spouse, not to your spouse and your children. If you have no surviving spouse, then to your children. And if you have more than one surviving spouse, and believe me, some people have more than one surviving spouse, intentionally or unintentionally, then different rules apply. Flavour of the month, testamentary trusts. Many of us use family trusts. You have assets, you set them up, you make an investment, be it in shares, in property. You might even run your business through a family trust. A testamentary trust is the same sort of animal, except that it is created by a will. An inter vivos trust, a trust you set up while you're alive, costa mozza. You usually have to set up a company and your trust deed and $500 stamp duty. All of that doesn't apply under a will. You appoint a trustee, you say, I give X to the trustee upon this trust, you've got a testamentary trust. You can set up a trust for purposes, to benefit people, to benefit institutions, and you can include your trustee among the beneficiaries of the trust. In the classic testamentary trust, you'll usually find that I will leave my estate to my wife, I will leave my estate to my trustees in a discretionary trust, and there's wording that goes around that, for my wife and my children and grandchildren. You've appointed the wife as the trustee. She is entitled to be a beneficiary of that trust, as well as the children and the grandchildren. Why are testamentary trusts so popular? Firstly, they give significant tax advantages, and secondly, they protect your assets from claims on your beneficiaries. If I give $1,000, no, I can't give $1,000, my wife can give $1,000, I can only give a share in my overdraft. If my wife gives $1,000 to our younger son, he's the profligate one, and he goes bankrupt, then any gift to him goes into his bankrupt estate, if he's bankrupt at the time that she dies. Which means that anything that he would have received from the estate goes to his creditors. And it could be a good deal more than $1,000. It could be our holiday home at Umina, and we don't want to lose that. Whereas if you give it on a trust for him and other people, or word it in such a way that the gift is not directly for him, then the creditors will not get a look in. More particularly, most of us have fears that our children and grandchildren are going to marry the wrong people. And when the predator, rather than the creditor, comes along and their marriage or their relationship goes pear-shaped, whatever you've given to them becomes part of the pool of assets that are going to be available in the family court distribution. If you place them in a testamentary trust, then they're going to be largely protected from being distributed to the predatory partner. Not completely. The family court has very special powers about looking through trusts, but it is the best protection that we can give at the moment. Looking at some particular tax advantages, if you have, say, a gift to your wife or husband, children and grandchildren in a testamentary trust, and it is what's called a discretionary testamentary trust, the trustee has the discretion whether to pay all or some of the income and the capital to any one or more of the beneficiaries. The same rules apply as do with family trusts. There must be a distribution of all income for each financial year, otherwise the trust will be taxed at the highest marginal rate. But provided that you meet that condition, the trustee can then decide, I will give, say there's an income of $50,000, $10,000 to the surviving spouse, and there are 2 children, $20,000 to each of the children. If they're on lower tax rates, then the overall tax that is paid will be lower, or to grandchildren, and I'll come to grandchildren shortly. As I mentioned earlier, a trustee can be among the beneficiaries of the trust. So if your wife is one of the trustees that is appointed, she can be part of the pool amongst whom the income and the capital from the trust can be distributed. The real terrific tax advantage is that under our Tax Act, income from a testamentary trust, not a family trust, but a trust established under a will, that is paid or distributed to a minor under the age of 18 is treated for tax purposes as though it were paid to an adult. If you pay income from a family trust to a minor child under the age of 18, they will be taxed at top marginal rates from about $600 on. I'm never quite sure of what the actual threshold is, but it's a penalty. But if you pay it to a minor, then they will get adult tax rates. Moreover, if there are capital gains made by the trust, and the trust is properly drafted in the will, any capital gains that the trusts make can also be distributed to the minor beneficiaries at adult tax rates, and if they are on lower tax rates than other adults, they will get a lower tax on that capital gain. I've just drawn a couple of quick examples to try and bring that alive for you. Imagine you've left $600,000 and the income from that at 5% is $30,000. If the person who's entitled to that income is on a 30% tax rate, they will pay $99,000 of that income in tax. If they're on a 38% tax rate, they'll pay $11,400. And if they're on a 45% tax rate, they'll pay $13,500. If you take that $30,000 and divide it by 3 so that each of them gets $10,000, then the first child would pay tax of $2,400. If it all went to one child, tax of $2,400, 2 children $300, and 3 children nil. I've also done some figures there if the income was $50,000 and how that would be distributed if it goes to a child or if it goes to somebody on a different tax rate. With income, capital gains tax streaming. Assume that you've bought 2,000 Australia Bank shares for $5 each when there was a float. They're now worth $45 each, which means they're now worth $90,000 in all. If they're sold by your estate, the capital gain is $80,000. You would be entitled to the 50% personal discount for the capital gain. So the capital gain on which tax would be paid would be $40,000. If the beneficiary, the person who you left that money to, left those shares to, sells those shares, and that person is on a 30% tax rate, they'll pay $12,000 in tax. If they're on a 38% tax rate, they'll pay $15,200. And if they're on a 45% tax rate, $18,000. This is all by direct gifts. We compare that then with what happens if it goes to children, and then what would happen if we have it streamed through a testamentary trust. If the gift is received by one child, the tax will then be $6,000, 2 children $1,800, and 3 children nil. Remember, what I'm talking here about children, it also applies to grandchildren, and particularly for younger grandchildren. Just a brief overview. In that example before with the capital gains tax, where the individual has to pick up the capital gains, all the capital gain and the capital gains tax, they've got to pay $12,000, $15,200 or $18,000 depending on their tax rates. But if you use a testamentary discretionary trust and it goes to children who are not in receipt of any other income, if it goes to one child or grandchild, the tax will be $6,000. If it's divided between two, it's $1,800, and if there are 3 children, there is nil tax to be paid. Each individual scenario has to be looked at separately. What would happen if the income from this inheritance were paid to this person on their present tax rates, and what would happen if there are children or minor children on lower tax rates available, amongst whom it can be distributed. I must be doing well, no questions. Okay.
They're a well-disciplined group.
Yeah.
The last question is, if I've
When you say children, you're obviously meaning minors.
Minors.
Because some people, I mean, I talk about my children and they're middle-aged people.
Yeah, but
So
your grandchildren.
Children means minors, yeah.
Yeah, in this case I'm talking about children, usually minors with no other income. So if our eldest son, if I leave something, or my wife leaves something in a testamentary trust to benefit him and his children, then the distributions that he can make through that trust to his children who are all minors, he can put it together in such a way that there is no tax to be paid. Whereas if he got the income, there would be some, if not higher. If you can sell your shares before you die, it may be better or worse, because if you can flog them before you die and you're in receipt of income, you're going to be you're going to be paying capital gains tax on whatever the capital gains is. And if your other income brings your tax rate up to a higher level, then you're going to be paying higher capital gains tax on that. Whereas if they're not sold and they go through a testamentary trust to minor children, it may be that the tax would certainly be lower, and it may be down to nil. But what you've asked just brings me back to one other point: superannuation. If you have superannuation, and as you put it, you know you're going to die, the trick is get the super out of your super fund beforehand, because if your superannuation gets paid to non-dependents, then there's going to be various taxes that are going to be paid, 16, 17% or more. Whereas if it's your superannuation fund and you are able to take it out yourself and then distribute that money through your estate, there would be no tax payable on the payout to you of your own superannuation. I mentioned at the beginning that I was going to talk about eligible persons. You don't have absolute freedom to make a gift to just whomever you please. Or better said, you do have freedom, but if there are any eligible people around, they may have a claim on your estate. Obviously, your surviving husband or wife is one of the people who has a claim on your estate. And the circumstances in which an eligible person has a claim on your estate are that, firstly, they're an eligible person, one of these people that I've listed here. Secondly, that you have not made adequate provision for them in your will. And thirdly, that they have need. If you exclude your husband or wife because you've had a falling out, you're in the process of getting a divorce, and there's not been a property settlement, then they will still have a claim on your estate if you exclude them. This also applies to a former husband or wife, or husbands or wives, unless you have had a property settlement with them. It also applies to anybody who was a de facto partner at the time of death, children of a marriage are eligible people to make a claim on your estate. So if you've decided that you have, say, 3 children, and one of them you've had a falling out with, or he's become a real ratbag, or he's become a drug addict, or he's abused you, or stolen from you, or he's behaved in such a way that you really feel that you don't want to call him part of your family and you want to exclude him from your estate, chances are, unfortunately, or fortunately, depending on what your social view is, that you can't, particularly if he has need. It's a bit like the position with workers' compensation claims. If you're injured at work and you do your best to rehabilitate yourself, the size of your claim goes down. You don't get rewarded for it. If you have a child who's behaved appallingly and they've become a drug addict or an alcoholic, chances are they've got greater need and therefore they've got a claim on your estate. I'm not suggesting that that's at all the case to anybody in this room, but if you're just talking to a mate and tell them about it, just remember, even your terrible children might have a claim. A dependent. Somebody who has been part of your household or a grandchild who was dependent on you and is excluded from your will may also make a claim on your estate. And then you have this lovely category, a person in a close personal relationship. A close personal relationship is not in this case a de facto relationship, but it is a situation where two people are sharing a household and one is providing personal services to the other, not for reward, in other words, without a fee. Then, if the first person who was receiving the services dies, the person providing those services would have a claim on their estate if they were excluded. Sorry, we're going through this at a great rate. I'd also like to look at 3 other convenient documents that you can use when you're thinking about how you should arrange and manage your affairs while you're alive. One is the enduring power of attorney.
Can I ask you a question, Norbert?
Ask your husband first.
Yes, you may ask a question, Pam.
Is there a time frame on de facto relationships or that bottom one that you had up previously, that they can make a claim on your estate?
That's a funny question coming from you, Pam.
Don't ask, David. De facto or close personal relationships. De factos. It used to be under the previous, the De Facto Relationships Act, but then became another act, that there was this 2-year time limit. And once you'd been living together for 2 years, then you were a de facto couple. That's no longer the case. It's now, if you're living together in what could be perceived by friends and family as living together as a couple, as more or less as husband and wife, then you are a de facto couple, even though you only started doing it last week.
Pardon? You started last week.
Yeah, it was intense.
Excuse me, Norbert, isn't that law different in different states?
I'm talking about the law in New South Wales, and I'm sorry I can't tell you in other states. It's
Many of us will have children that reside in different states.
Right. You'd have to look at the law in the individual states about when a de facto couple comes into...
I just want to make the point that
Yeah.
I know the law is different in different states.
But I still
Others
think...
may not be aware of that.
Yeah, but I still think, isn't it, that the main test is, are they ostensibly living as husband and wife, in other words, sharing a household, sharing expenses, and are seen together as a couple? I think that's still the same test through most states.
Yeah, but some states have specific time frames
Might well be.
that you have to live together for.
Yeah. It used to be 2 years here as well. Okay. The 3 other documents I just wanted to mention briefly. How are we going for time?
Yep, another 5 minutes or so.
Okay. First one is a power of attorney. Now, a power of attorney is a document that you sign to give somebody else or some other people the right to sign documents for you. It merely entitles the attorney to sign documents for you. And you've probably heard about you've heard the phrase an enduring power of attorney. An enduring power of attorney means that the document, the power of attorney, will continue to be valid and effective even if you, as the donor, become incapacitated. So even if you don't know what's going on, you're in hospital, you're in a coma, you have an accident, the power of attorney that you give to the attorney will still continue to be effective. But remember, it's only to sign documents for you, legal documents. The other document that I would recommend in many cases that is signed is what's called an enduring guardian. And this gives the person that you appoint the power to make medical decisions for you, where you should live and what medical treatment you should receive, but only if you yourself are no longer able to make those decisions. Only if you become incapacitated can that person then make those decisions. Going back to the power of attorney, as soon as you sign that document becomes effective. What that means in effect is that both you and the person that you've given the power of attorney to can both sign legal documents unless you've said otherwise in the document itself. In an enduring guardianship, I sign it today, but it stays in abeyance until I'm in hospital and I can't make the call myself.
Thanks, Norbert.
Norbert, who is empowered to make that decision on whether you are capable or not?
In the case of the enduring guardianship, the treating medical practitioner would make that decision.
And what about the other case?
In the power of attorney, it doesn't matter. It will continue to be effective whether you're compos or not compos.
I thought it only came into effect when you weren't capable.
No. Perhaps if we can just go through this summary that's up here now. Power of attorney, just for documents. Enduring guardian, personal, lifestyle, medical matters. Power of attorney can't decide on medical matters. A guardian can. A power of attorney is effective immediately it is signed. An enduring guardianship only when you become incapacitated and are unable to make that decision. If you're concerned about when that point has been reached, you can build into the document a way of measuring. You could describe who has to make that decision, for argument's sake, by a medical practitioner or two medical practitioners, each of at least 5 years standing. And if they say you're not able to make that decision, then the enduring guardianship will be operative. Sir?
Yes, is it possible or wise to appoint more than one power of attorney and an enduring guardian?
I think it is in most cases. You can do it one of two ways. You can either appoint people to act jointly, or you can do it so to appoint people to act one after another by default. You appoint X, and if X is dead or not available, then you appoint Y. It depends on your own personal circumstances. It also depends on who you trust. Who do you want to make those decisions about you or for you, and who is in your immediate family or otherwise the people that you would want to make those decisions for you. But certainly, in many cases, it is wise. The downside, of course, you can appoint two and they can disagree, and what are you going to do then? It's really is a call that has to be made on an individual basis. The final document that I wanted to look at very briefly is a declaration of medical wishes. You've probably heard of living wills. Living wills are not wills. They are a document that gives some direction to the people who are going to be responsible to look after your medical treatment and your medical care, to tell them what you want done, or not done. Euthanasia is not yet legal in Australia, and certainly not in New South Wales, but you can put into your declaration of medical wishes that if there is no reasonable hope of your recovery, if you can't interact meaningfully with your environment, if, say, two medical practitioners make that call, then no heroic measures should be taken to keep you alive. I think something like this is a great comfort to those people who are left behind, to know what it is you wanted, that you thought about it, when you were able to think about it, and you were competent to think about it. It's also very important, I think, to have this if you're alone and there's not likely to be anybody around to make that call for you. I said I was going to show you the best will I ever wrote. There it is.
Sorry, big one.
Well done.
I just wanted to ask, you know, you're trying to make sure none of your children feel left out or whatever, and if you have an odd number like 3, which we have, should I mean, I thought three executors or whatever seems a bit over the top, but I don't want one child to feel they've been sort of left out or ignored or thought lesser of, if you know what I mean. So is it too unwieldy to have 3? I mean, they get on, these 3 children of ours get on, you know, we're a pretty close family. There's no sort of major problems. So is it too unwieldy to have 3? I was always told 3 is too many.
The youngest is 48, by the way, talking about children.
Okay. I can't give, there's no yes and no always right answer in that situation. It depends on the individuals, it depends on their personalities, it depends on the way they get on. But you can also build some mechanisms into the document so that if you appoint 3, you can say the will of the majority. If 2 decide to do one way and 1 decides, no, I don't like it, then he or she may just have to wear it. You'd have to specify that, because the rule is that if you appoint people to act jointly, they have to act jointly, not by majority. And if they don't all agree, then nothing happens, unless you say in the document, if 2 of them don't agree, then then the will of the majority can prevail. Or you can, for argument's sake, put in a backup mechanism. If they don't agree, then they're to refer the question to somebody else. Maybe there's a family advisor. Maybe there's been a solicitor who's been around for for yonks that can assist them, or maybe a financial person. It really depends very much on the situation. But hey, I'd hate to make the call of leaving one out without. I'm the one that's been left out of this.
Because in my experience...
Sorry, Joan, I'm sorry, yes. Bruce, yes.
Yes, thank you. Can you expand in regard to the guardianship tribunal and the guardianship board and their roles these days?
The guardianship tribunal and the guardianship board takes over those functions of both a power of attorney, an attorney, or a guardian, if one has not been validly appointed, or if that appointment is properly upset by an application by somebody else. They work fairly informally. They make 2 sorts of orders. They make financial management orders, which are the same as giving somebody a power of attorney, so they can go to the bank, decide what money is going to be spent, how it's going to be spent, and so on. Or they make personal orders for your personal care, which is the same really as an effective guardianship. In most instances, if you sign a power of attorney and an enduring guardianship, and you've got your wits about you when you do it, and there's no suspicion of fraud or undue influence, the guardianship board is not going to really upset that, because you've done it while you're alive. That's what you wanted. That's where they start off.
I just would like to point out a recent experience of my own family. My wife's mother was in a dementia unit for 10 years, the last 10 years of her life. And previous to that, to her entering that state, my wife was under the impression that she did have power of attorney for her mother. But at some stage, and she was making decisions and signing things for her, it became apparent that it wasn't an enduring power of attorney. It had been made while my mother-in-law was quite healthy, and I think she made it so that when they went overseas and were away for different times. And so the affairs were then put into the hands of the guardian, the state guardian,
yes.
and it made it much, much more difficult
Absolutely.
to manage that. So the word of warning in this is that you must make sure you have an enduring power of attorney and not just a power of attorney that allows you to manage your somebody's affairs.
Absolutely. Thank you for that.
That was quite a difficult situation. Made a difficult situation quite a lot more difficult.
This is because the basic rule is that if I give you the power to act for me, to sign documents for me, I must be able to ratify what you do. In order to ratify what you do, I must understand what you do. If I am no longer competent, if I'm disabled, if I'm incapacitated, and can't understand what you're doing in my name, I can't ratify it. And it was for that reason that they introduced this concept of an enduring power of attorney. I think it was in 1992 or thereabouts, under the Power of Attorneys Act, so that the power should remain effective after somebody suffered incapacity. But in order to be an enduring power of attorney, it has to be witnessed by a lawyer who has to certify on it that the person understood that this document would continue to be effective after they suffered lack of capacity. But absolutely, you have to be very, very particular about that.
Norbert, the next one.
Sorry.
Norbert, doesn't that give a bit of a problem then? What you said earlier was the enduring power of attorney takes effect as soon as it is signed.
Yes.
Now, if I give somebody, like the gentleman just mentioned, an enduring power of attorney, I'm still perfectly capable of making my own decisions. I've given this other person the ability to make these decisions.
So the two of you have that ability. Okay.
Yeah, but I don't want that person to have that ability until I'm not able to make decisions. How do I
Okay,
make it like that?
two things. Firstly, the person to whom you give the power of attorney, the attorney, is under a basic duty to only act in your interests. They are under what's called a fiduciary duty. So they should only do what you want. Not much comfort. If they don't, you can sue them. The practical way is you prepare that document because you never know when you're going to need it. You can, the bus principle. But you keep that document safe. The way I do it, if somebody executes an enduring power of attorney, I keep it in my safe. And if the attorney rings me to say, Nigel's gone overseas and wants me to pay $10,000 to them, I will send you an email or ring you or somehow and say, I'm not letting go of this document until I get confirmation from Nigel that this is what he wants. And I think most lawyers will do that. They'll even put that in writing.
That's a very good point, isn't it?
But again, I guess it comes back to who are you going to appoint as your attorney and do you trust them? And what is your relationship with them?
Now, I'm conscious of the time because we've got to get Norbert back to the city by 5 o'clock. So is there one last question?
Yes, sir.
That's two. Is it two all right, Norbert?
Yeah, yeah.
You go. John goes first.
Yes, John.
If you did a normal sort of cascading will many years ago, sort of before you had children, but you sort of said your wife and then your children, essentially, that. But it's a long time ago. Since then, you've actually established, or you've had children. You've established more assets. Is that will still sort of viable?
Yes. There are a couple of circumstances that automatically cancel a will. If you did that will and remarried, then that will would be automatically cancelled. Marriage automatically cancels any existing will unless the will is made in contemplation of that marriage. But otherwise, it probably would be perfectly viable, but it would probably land everybody in a bigger mess. Because if you did that at the time when you were thinking about buying your first home and you had a bank account and no children, since then you've had a business, you've probably established a trust, you've got some investments, you've got to give a little more thought about how those should be effectively dealt with, particularly who's going to control any family companies that you might have, or family trust that you might have. So my general advice is, if I prepare a will, don't put it in the bottom drawer and forget it. Take it out every 3 or 5 years, look at it. Is this still what I want? Is this still effective? Will this still work for me? And if not, then update it. If there's been a dramatic change in your life, somebody has passed away, you've had some dealings with children or grandchildren, you've won the lotto, you've lost everything, then have a look again. Sorry, is that okay, David?
Yes, we've had a discretionary trust for 40 years, established by my late father.
Yes.
Because I had a few problems in lifestyle, should I say, and he wanted to...
No, probably in this group you shouldn't say.
No, we want to hear more about it later.
Yeah.
The only assets in the trust are 2 shares in a company.
Yes.
I'm not an appointer of the trust.
Yes.
I'm not a beneficiary of the trust.
Right.
And we have the 2 shares that are in the trust, which is a proprietary limited company.
Yes.
For which, again, I'm not a director, I'm not a shareholder, and I don't get paid a dividend. How secure, when you look at what's happening today with a big mining entrepreneur
who wants to run a soccer team?
No, the other one.
The Australian of the Year, Jesus.
And also a large property developer,
yeah,
are trying to remove trustees and change the basis of the whole thing. How secure is the trust?
I'll try and do this without weasel words. It's going to depend on what the terms of the trust were when it was set up. And I take it when you're talking about 2 shares in a company, that's actually a corporate trustee, and that somebody else owns those shares and controls the trust, and that trust then has property or other things in it. How secure is it? Well, yeah, when I've spoken to Gina next week, look, it's still the best vehicle we've got. And like most things, it depends on how good are the people who are controlling it. But I think it would still be, it'll still work.
Thank you.
Okay. Well, we better call up Stumps now because, as I said, Norbert's got to get back to the city by 5 o'clock. So, Norbert, on behalf of the Sydney Adventist Hospital Prostate Cancer Support Group, your presentation was first class, as I knew it would be, and you didn't let me down. We really appreciate it. It's fantastic to get these insights into all the other matters that us people that are going through the prostate cancer journey, for instance, to make sure that we've got everything under control. Whether we need it shortly or whether we need it in 25 years' time, this is all very important stuff. And that's what we're trying to do, to bring this information to you. So, Norbert, thank you very much for a first-class presentation.
Pleasure.
Could you help me thank Norbert?
Thank you. Thank you very much, David. It's been my pleasure. Really, if you've got any questions, talk to your lawyer about it. I know the fees are extortionate, but if you look at it as an insurance premium, I still think it's fairly low.